Well, I'm saying the way I talk, my speech has got no cadence, it's got no rhythm, it's got no pattern. It sounds like a 3-year-old is uttering. It sounds ridiculous.
Right.
I get rid of all. There's no way they can answer it. There's no way. They just look at it and say, there is no word in here that we can possibly manipulate, spin like I did with you. You said the pen is red. Red is pen? Really?
Right.
Like pen equals red, red equals pen? No. Is red. Yeah, but see, that's what I'm saying. You make it so. Bill Clinton did that. What is. What's your definition of is? Say, he was funny. What's your definition of is? So he's doing is like I do.
Right. What he used is as a verb and a pronoun in the same sentence. Well, that's what I was kind of curious about because, I think you know what study I've engaged in. I've followed a lot of study on that, and I always really wondered just how important it was because, the claim is the language is modified, but is it true that if we express our volition accurately to the court, how much can they manipulate that in our words? In other words, if we're not using proper syntax, can they, I know they're not going to tell you, but have you found that to be an issue, or can we communicate our volition by the common language?
They just throw it in a garbage pail. They'll just laugh at you, smile, and throw it at the garbage pail. That's why I say to people, if you make it more than 2 lines long, you're in dangerous water. Because any little utterance is that's not pure, they're just going to bounce it off here. So, he gave us a wiggle room. Oh, thank God, he gave us that loophole. Oh, thank God, he gave us that wiggle out. Thank God, he did it. Whew, did you notice that? Yeah, I saw that. He almost got us.
Mm-hmm.
And it's just that simple. They got it. They're like, thank God. But like I said, that's why, I try to run like hell from those guys and try to get it into in front of a trial by jury. Usually, if I'm the guy who, like I said, that's why it's every case is unique like that because you have to say what is the common belief of the people in that district. Like I always say to people, in O.J. Simpson's case, if he had the case in Brentwood, California, or Beverly Hills, he would have been found guilty. If he had it down in Hollywood, or southeast Los Angeles or something like that, or Long Beach, he was going to be found not guilty. Just what's the common beliefs of the people in that area.
Right.
So sometimes you want to go before a guy in a black robe because his is basically you're going to throw the book at him and say, look, this is the book. Just carry out the letter of the law. And he's going to say, okay, I got to carry out the letter of the law. I'm stuck. There's nothing I can do. Is this what the contract says? It's black and white. Is this what the page says? It's black and white. I'm here to maintain status quo. I'm not here to interpret. I'm just here to, maintain the position as it's already been established. Then you could use precedent and citation, case law, and statute and all this other nonsense. But like I said, sometimes you want to use the jury. It's like, forget about all that nonsense. Look, let's just wing it. Let's just do this on a fly. And that's when you call in the jury. And then you got to pick out the jury carefully and say, they're going to tolerate this kind of crazy belief that I could drive without a driver's license. The jury's going to throw the book at you. The guy in a black robe, he'll say, yep, you could drive without a driver's license. Nobody said you had. But the jury, they'll say, no. If we got to do it, you got to do it too.
Sure.
So you got to be careful, man, when you always say, oh, I love a jury. No. And that's what people used to always get me wrong. People used to start on my shows months ago, and they would say, well, this is what Karl says. Karl always says go to a court of record and trial by jury. No, that's not what Karl always says. Absolutely not. When we did a court of chancery down in Tennessee, it was great because the mortgage clearly defined in they were the breach of contract in section 5, 6, and 9. The bank was in breach of. So why in the world would you want to mangle it up with trying to get a jury to understand the whole entire process when you could get a guy in court of chancery, the equity, the judge who already proficient in contract or mortgage law? Why would you want to waste your time when you could just clearly show the guy in a black robe, look, they're in breach under 5, 6, 9. Clearly, it's been established that they must do this. They did not do this. And that's it. There's no wiggle room for the other people. There's no, is it established? Is that the rule? Is that what you signed to? Yes, then just carry it out. And that's why I tell people, when you read your mortgage, you won't believe how many times in breach that the bank is. I said, then just bring that up to the court. Don't worry about a jury. The guy in a black robe is not stupid. He could read what the contract says.